bring this meeting to order. Alright, good evening everyone. For those of you who don't know, we have a few new faces here. My name is Marlene. I am president of our local Federalist Society chapter here in Mobile, the Brevard and Howard chapter. The Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society promotes and seeks to educate the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. We're very excited tonight to host Colonel and Professor John Eidsmoe to speak to us on the death of the living Constitution. For those of you who do not know, we do have a social media presence. We try to promote all our events and update everyone in the group about our future events. We're on www.facebook.com/handhoward. That's in Brevard, Handhoward. And we're also on Twitter at Mobile AL Chapter. I always try to update that with timely legal topics, the Constitution topics, about our current speakers and the presentation that we have. Tonight we're going to talk about two, what I call schools or orthodoxies of constitutional interpretation. There is the originalism and another competing theory of constitutional interpretation, that those who interpret the Constitution as a living constitution or living document. For those of you who are not really confident of what originalism means, originalism is a method of constitutional interpretation where the judge interprets a constitution based on the original meaning or original text of the instrument itself, of the meaning that the founders of our Constitution, the writers of our Constitution, framed our written document in. It's hallmarked by judicial restraint and fidelity to the actual language of the Constitution, where the focus is on the goals, objectives, and purposes of those who wrote the Constitution, and giving the meaning to the phrases of the Constitution and language of the Constitution that the founders used. A competing ideological orthodoxy of constitutional interpretation is that of a living Constitution, which Colonel Eidsmoe will speak tonight about. And briefly, a living Constitution, those who believe in such a thing, believe that the Constitution is an organic document, one that should be adapted to meet perceived needs based on the current change in circumstances. One whose words and meaning change over time and develops to meet and adapted to meet the ever-changing needs of a dynamic society that was not envisioned by the founders. It's what do the words mean in our time. That's basically, in a sentence, how these people, or these constitutional interpretation, this constitutional interpretation is decided. The dangers of the living Constitution approach will be explained in greater detail by Colonel Eidsmoe, but this jurisprudence has dominated constitutional law for most of the past century. Colonel Eidsmoe will tell us, based on this postmodern view, truth is subjective and language deconstructionist theory that words are merely social constructs with no intrinsic meaning. This approach has empowered judges to effectively rewrite the Constitution and find new and previously unheralded rights in the emanations and penumbras that flow from the Constitution. There's a process that we have in the Constitution that provides for this, and that's the amendment process. Those who follow the living Constitution theory rewrite the Constitution, sleight of pen in misinterpretation, or adapting the Constitution's words to meet their own needs or to reach a goal that they feel is in the best interest of their own ideology. The living Constitution jurisprudence can be dangerous to liberty. Colonel Eidsmoe will tell us that because the same court that can read into the Constitution rights that are not there can also read out of the Constitution rights that are there. Instead of evolving upwards towards greater recognition of human rights and human dignity, society can move in the opposite direction towards a new age of barbarism, according to Colonel Eidsmoe. Only an enduring constitution, not a living constitution, can provide lasting protection for human rights. Now, before I introduce Colonel Eidsmoe tonight, John Eidsmoe is a retired Air Force Lieutenant Colonel in Alabama State Defense Force Counsel, Colonel, and a graduate of the Air Command and Staff College and Air War College. He is a professor of law at the Brook College of Law and Government Policy, and in his various teaching assignments, his students have given him the Outstanding Professor Award or Professor of the Year Award 5 times. He has served as senior staff attorney with the Alabama Supreme Court and is currently legal counsel for the Foundation for Moral Law. He is an ordained pastor with the Association of Free Lutheran Congregations and serves on the board of Lutherans for Life, on the board of the Plymouth Rock Foundation, and on the board of the Gospel Martial Arts Union, and is a constitutional attorney who has defended homeschool cases, Christian schools, the rights of students to study the Bible in public schools, and the right to display the 10 Commandments in the public arena. He has authored 14 books, many of which are outside, available after tonight's presentation, if you wish to purchase, including Christianity and the Constitution, God and Caesar, Columbus and Cortez, and he has produced numerous audio and video lecture albums, including the Institute on the Constitution and Here I Stand, a biblical worldview for a new millennium. A lifelong student of the Crusades, he is a Knight Commander and Chaplain for the Sovereign Military Order of the Temple of Jerusalem. He is a 3rd degree black belt with American Taekwondo Foundation, a 5th degree black belt with Gospel Martial Arts Union, and a 5th degree black belt with the Black Belts of the Faith International. Colonel Eidsmoe is an avid horseman and skier and tries to get 8 hours of sleep every week. He and his wife, Marlene, have been married since 1970. They have 3 children, David, Kirsten, and Justin, and live in rural Pike Road, Alabama. Please join me in welcoming Colonel John Eidsmoe.
Well, what I'm faced with right now is a good part of my speech has already been delivered by President Reagan, by Justice Scalia, and by Matt. And nevertheless, we'll have a lot of other things to say here. When talking about the formation of this constitutional republic, I came to realize that I'm 67 years old, meaning that my life is getting close to half over with. And when you consider the beginning of our nation in 1776, the nation is 237 years old. It's kind of both makes me proud and makes me feel old to think that I have lived through more than 1/4 of our nation's history. One of the things that really makes you feel old is when you're teaching a history course and most of the stuff you're teaching is stuff you remember happening or forgot. But I think there's probably nothing that makes an old professor more pleased and proud than to see his former students out there in the arena, taking the principles that they've learned and applying them, as Matt Green is doing right here in his practice, and with the Federalist Society and many others here as well. And obviously, though, we can't really expect our students to just think exactly like us and do exactly what we've done. And so everything that Matt Green says and does that's good, he learned from me. Everything otherwise is on his own. Anyway, it's great to be with you here tonight and talk about this issue of the living Constitution, and I think you heard it quite well defined by Justice Scalia and by President Reagan, and the other presentation as well by Justice Sotomayor. To give you an idea of what the issues involved here are, I would suggest to you that there are really 2 overriding issues that face the legal community, not just in America, but worldwide today. First of these is whether constitutions, ours and others, are to be interpreted by the letter as intended by the framers, or whether those who interpret them are free to inject their own interpretations. And the second issue, which I suggest is even more fundamental, is whether or not there is a higher law to which human law must conform, or whether law is law simply because the highest human authority, the state, has said so and has the power to back it up. And so what I'd like to address tonight then, first of all, would be the rise of the living Constitution, and then alternatives to the living Constitution, the alternative that I'm going to describe as the enduring Constitution. So as we look to the rise of the living Constitution, I think we need to first of all understand the worldview of the framers who drafted the Constitution and the Declaration and other founding documents of this nation. And I would never suggest that they're all in agreement on every point. They come from a variety of church denominations. They come from a variety of professions, military, farming, and law being among the three most prominent professions they came from. They came from northern climates like New Hampshire, southern climates like Georgia, different occupations, different backgrounds, different training. But I would say there are two things that would unite almost all of them, and I say almost because as a lawyer we always like to make corrections and qualifications like that, but I would know of no exceptions. The first would be a high view of God and His law. Not all of them were Christians. I would argue the vast majority were. In fact, in this book, Christianity and the Constitution, I read about 50,000 pages of the framers' writings to try to discover their religious beliefs. And I can say that the strong majority of them were actively involved with Christian churches. 28 were Episcopalian or Church of England. 8 were Presbyterian. 7 were Congregationalists. There were 2 Dutch Reformed. There were 2 Lutherans, and I think that might be my native South Dakota delegation, except I'm not sure they made it. 2 Methodists, 2 Roman Catholics, 1 whose religious preference we simply do not know, McClurg of Virginia. He was buried in an Episcopal churchyard, which indicates probable church membership, but we don't know that for sure. And that would leave about 3 of them as being unorthodox in their religious beliefs. One of these being Ben Franklin, who I would argue was not a deist, although he had been earlier in his life, but was probably something like Unitarian, although he never specifically identified himself as a Unitarian. And what I find interesting is when you see Franklin there at the convention, on June 28th, when the convention is in danger of breaking up, there's so much discord, it is Franklin, the oldest delegate there and possibly the least orthodox delegate there, who makes a motion that they have daily prayer. And I'm just going to read a little bit of what he said in that speech for that motion. He says, reminding them that they had met here in the same hall, Independence Hall, during the War for Independence. In the beginning of the contest with Britain, when we were sensible of danger, we had daily prayers in this room for the divine protection. Our prayers, sir, were heard, and they were graciously answered. I have lived, sir, a long time, and the longer I live, the more convincing proofs I see of this truth, that God governs in the affairs of men. Now, believing that doesn't make you a Christian, but it's as direct a repudiation of deism as Franklin could possibly make. And he goes on to say, and if a sparrow cannot fall to the ground without his notice, is it probable that an empire can rise without his aid? We have been assured, sir, in the sacred writings, that except the Lord build the house, they labor in vain that build it. I firmly believe this, and I also believe that without his concurring aid, we shall succeed in this political building no better than the builders of Babel. I could go on and talk about the religious convictions of many, many other of the founding fathers, but I'm just giving you a little flavor that they would hold to the idea of a high view of God and his law. As Jefferson, who also was unorthodox in his beliefs, again, probably Unitarian, but you have to remember Jefferson was the primary author of the Declaration of Independence, but he was not a delegate to the Constitutional Convention, nor was he even in the country when the Constitution and Bill of Rights were drafted and ratified all of this time. He was serving as ambassador to France. But in the Declaration of Independence, Jefferson says that we are entitled to our independence by the laws of nature and of nature's God. And he goes on to say that we are endowed by our Creator with certain unalienable rights, and that we are created, not evolved, equal. In other words, the idea that there is a higher law to which human law must conform is clear in our founding documents, and it clearly is the belief of the overwhelming majority of the framers. Second would be a low view of man and his nature. They didn't buy into any of the nonsense of the French Revolution that people are good and that human nature is perfectible. They knew that was not the case. Alexander Hamilton, for example, says on the floor of the convention, "Take mankind in general, they are vicious. Their passions may be operated upon." And on another speech, he says that till the millennium comes, in spite of all our boasted light and purification, hypocrisy and treachery will continue to be the most successful commodities on the political market. James Madison, a man who many call the father of the Constitution, and he certainly had a lot to do with that, although I think there are several others that would contribute almost as much, one of those being Gouverneur Morris. Morris spoke more frequently than any other delegate of the convention. He chaired the Committee on Style that wrote what basically, with a few modifications, was the final draft. And so you might possibly say that Madison was the father of the spirit of the Constitution, Morris was the father of the letter of the Constitution. But before going into law and politics, Madison went to a little college called the College of New Jersey. Maybe you've heard of it. It changed its name recently to something like Princeton. But anyway, there at Princeton, he studied under Reverend Witherspoon, intending at first to go into the ministry, stayed a full semester after graduation so he could study Hebrew, could read the Hebrew laws in the original language. And in Federalist number 51, it is Madison who says that what is government itself but the greatest of all reflections on human nature? Then he says, if men were angels, no government would be necessary. If people were good, we wouldn't need government. But then he says, if angels were to govern men, no control on government would be necessary. If we had a few wise, benevolent philosopher kings, we could just give them absolute power and trust they would use it in everybody's best interest. But he seems to be saying here that we aren't angels, and those who run the government aren't angels either. And I think maybe recently some of us have begun to suspect he might be right on that. And so he says, in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. And so that was the basic problem the delegates faced at the convention. How do we enable the government to control the governed? How do we require it to restrain itself? And the answer to that, I suggest, is what I term the Founding Fathers' five-fold formula for freedom. And if you like the alliteration, I could throw in famous, fantastic, fabulous, and a few others too, I suppose. My homiletics professor in seminary would like that, but everybody else would roll their eyes. But anyway, those 5 points, or the five-fold formula, would be number one, government of limited and delegated powers. That is, government has only the power that we, the people, have delegated to it through the Constitution. All others are reserved by the 10th Amendment to the states or to the people. Second, separation of powers. The powers we do delegate to government, we separate vertically, federal, state, and local, separate horizontally, legislative, executive, and judicial. Third, checks and balances. The idea that we're not going to just let each one of these branches and each one of these levels go its own way. If we do that, we'll have a many-headed tyrant instead of just one tyrant. And so we have checks and balances. For example, Congress passes laws, the president can veto those laws, Congress can override the veto with a 2/3 vote of both houses. The Supreme Court, arguably at least, has the power of judicial review, but there are checks on the court. They are nominated by the president, subject to confirmation by the Senate. The Congress controls their budget, the executive has to enforce what they do, and so on. And so the idea here is of checks and balances back and forth like this. And I might add also that there are checks between federal and state. For example, the federal government, according to Article 4, is required to guarantee to each state a Republican with a small r form of government. But also we have an important check on the federal government, or I should say we had an important check, and that was that when we look to Congress, the House of Representatives is elected by the people, which is one of the reasons that the Constitution requires in Article 1, Section 7 that all revenue-raising bills have to originate in the House. I'm going to talk about that. I might say that the Foundation for Moral Law, where I served, was commissioned by Liberty University to draft the amicus brief that directly addressed the origination clause issue in their case before the circuit court right now. And anyway, that's a fascinating issue. But the Senate, as you recall, was not elected by the people. The Senate was chosen by the state legislature. And so that meant that each state legislature had a check on Congress. If one house of Congress is composed of people appointed by state legislatures, it's going to be pretty hard for Congress to do something that the states are adamantly opposed to. Now, of course, that's changed by the 17th Amendment of 1913, and now we elect our senators, and I still make the argument that this does not affect the validity or importance of the origination clause. First of all, that senators still represent states. It's just that the method by which they are chosen is different. And secondly, when the 17th Amendment passed, if they wanted to modify the origination clause at that point, they could have, and they didn't. But at any rate, checks and balances, and I've only identified a few, and then reserved individual rights. The idea that we are not a pure democracy in which even a majority of the people have unfettered power. In a republic like ours, the majority generally runs things, but the minority has certain rights that even the majority cannot take away. I heard a pretty good description of it once, and somebody said that a democracy is 3 wolves and 2 sheep planning dinner. A simple republic is 3 wolves and 2 sheep electing somebody to plan dinner. A constitutional republic, like our founders designed, is a society in which nobody has authority to plan dinner for anybody else, and the sheep are armed. So are the wolves, but at least that makes it equal. By the way, we talk about these issues of the Second Amendment and right to life issues, put them together. I saw a really neat bumper sticker that I had to copy off the interstate and put up on my door at the office. It says, if babies had guns, they wouldn't be aborted. And so let every baby be armed, be a campaign we can go on. Every abortion doctor has to be worried that this kid might be packing heat, and who knows. Anyway, and finally, responsibility through religion. Now, the framers did not want a state church, and neither do I. When you look to the concept of separation of church and state, and that is a legitimate term, despite the way it's been misused sometimes today, the first society in all history that I can find that ever practiced separation of church and state is Old Testament Israel. You recall that the kings, the civil authority, come out of the tribe of Judah. The priests, the religious authority, come out of the tribe of Levi. You see separate institutions, and yet both derive their authority from God, and both are, in some ways at least, subject to the law of God. The framers did not want a state church. They had seen the worst form of state church in England, where the king was actually the head of the church as well. Nowhere else in the Western world, even in The darkest of the Dark Ages, was that ever true? In medieval Europe, the Roman Catholic Church and state kings and so on would interfere with each other, sometimes in ways that were improper. But you didn't have kings becoming popes or popes becoming kings. That is only true in the 1500s with Henry VIII in England. Anyway, that's another subject. What the framers did intend, however, is, as George Washington said in his farewell address, that of all the dispositions and habits that lead to political prosperity, religion and morality are indispensable supports. And when 20 clergymen wrote to him thanking him for that address, he wrote back, thanked them in return, and said, religion and morality are the very pillars of civil society. And John Adams, our second president, possibly the greatest scholar ever to occupy the White House, that when John Adams simply said that our Constitution was made only for a moral and religious people, it is wholly inadequate for the government of any other. His meaning was that without a moral, disciplined, virtuous populace, self-government was impossible. And that kind of morality and discipline is going to be instilled by religion. And when they use that term religion, they generally used it pretty much interchangeably with Christianity. Anyway, so there is the worldview of the framers. There is the Founding Fathers' formula for freedom. But now let's look to the changing worldview of the modern era. Two things I think have changed things a great deal. One of them is Darwinism, and I'm not so much concerned here with whether you accept Darwin's theory of natural selection as a theory of origins. I'm more concerned with its worldview implications. The idea that truth and everything else is changing and evolving with time. Now, the framers didn't see it that way. In fact, you could say the framers were very much Newtonian. They saw the universe in terms of fixed absolutes, fixed God-ordained absolutes. And when Hamilton, for example, described the Supreme Court as the least dangerous branch of government because, as President Reagan said, they exercise only judgment, he assumed that would be a limited role because they would be interpreting the Constitution and exercising judgment according to a fixed standard. But with the Darwinian worldview, all of that changes. And Richard Hofstadter, the sociologist, made the observation that many discoveries have affected ways we live far more than evolution ever did. But none have had as great an impact on ways of thinking and believing. He went on to say, in that respect, the space age does not promise even remotely to match it. Darwinism, the idea of doing away with absolute fixed God-ordained truth and moving toward a more fluid and changing view of truth, we can see that reflected in the school of law that we have at Harvard starting in the 1870s, legal positivism. But before I get to positivism, let me mention one thing more here, and that is another development that comes a little later, a little after Darwinism, but as a result of it, and that is what we call the postmodern movement. Well, when I first heard that word postmodern, I thought, I don't even know what modern is. What do you mean by postmodern? Well, if we were to define modernism as formulating your views of truth based primarily upon reason rather than on the revelation of God, if that is the modern, postmodern is going a step beyond that and saying that we don't base our views necessarily on reason. Rather, truth itself in this view is subjective rather than objective. You know, just to understand the difference between objective truth and subjective truth, if I were to say that that tree out there is a palm tree, that is an objective statement. I believe it's true. Now, we don't have palms way up north in Montgomery quite like you do here. That, I would say that is true. But you could do scientific analysis and you could verify or falsify what I've just said. And an objective statement could be objectively true. It could also be objectively false. I could say there's a Tyrannosaurus Rex out there. That is an objective statement, objectively false, but objective. Now, a subjective view is things that are a matter of perception or opinion. If I were to tell you that Johann Sebastian Bach is the greatest musician who ever lived, in my opinion, that's pretty close to being objective truth. But at any rate, you might say, well, I respectfully disagree. I think Ice-T is the greatest composer who ever lived, or whatever your taste happens to be. Or if I were to say to you that my wife is the most beautiful woman in Alabama, gentlemen, if you're doing your job properly as gentlemen, you'd probably say, well, your wife undoubtedly is beautiful, but with all due respect, I think my wife is the most beautiful. And even though there are some objective standards there, I think we have to say there is some truth in the idea that beauty is in the eye of the beholder. If I say that vanilla ice cream tastes better than chocolate ice cream, that's a subjective statement. But the postmodern idea is that all truth is subjective. All truth is a matter of your opinion. It's not a matter of whether it's true out there in some foreign realm. It's what's true for you, what's true in your mind. So I remember we had an incident in our church about whether or not Santa Claus existed or not. A Sunday school teacher said there wasn't a Santa Claus. Several parents were upset about that. One of the parents simply said to her daughter, well, do you believe in Santa Claus? Yes. Then for you, he's real. Kind of like what I was thinking one time. I was like getting presents. So I was tempted to say once that, well, I believe in Santa Claus, but this is the last year. But anyway, the idea that all truth is subjective. Story is told one time about a group of math teachers who got together, and the classical math teacher said, well, I just can't understand all this new math and fuzzy math today. I've always taught that 8 minus 4 equals 4, always have, always will, and that's going to be true no matter where or when you say it. And another math teacher said, well, I don't quite teach it that way. I teach the Hegelian view that 8 minus 4 used to equal 4, and that was a thesis, but an antithesis arose that 8 minus 4 equals 6, and out of the tension there came an antithesis that 8 minus 4 equals 5. And then the Darwinian math teacher said, well, I just teach a little different from that, but the same result, that at one time 8 minus 4 equaled 4, but the 4 evolved into a 5. And then the postmodern math teacher said, I don't teach that 8 minus 4 equals anything. I just tell my students to write an essay telling how the number 8 feels about having 4 subtracted from it. Or another story along the same lines there is the baseball umpires got together. The classical umpire said, well, nobody's going to bribe me. And I call them as they are. And that's all it's going to be. I call them as they are. And then another said, well, I'm not quite as sure of myself as you are, but I call them as I see them. And that's not so bad, recognizing that there is an objective reality out there, but that we may not always fully grasp what it is. And then came the postmodern umpire who said, they ain't nothing until I call them. That's a subjective view of truth. And you could apply that in drama, for example, especially if you bring into this language deconstruction where words have no intrinsic meaning and whatever the reader wants to draw out of the words is what counts. If you're in drama, for example, if you're a classicist and you're putting on Shakespeare's Romeo and Juliet, you'll probably try to put it on as close to what Shakespeare would have intended by it as you possibly can. But if you're a postmodernist as a drama instructor and you want to morph Romeo and Juliet into a modern West Side Story, nothing wrong with that in the postmodern and deconstructionist view. And that may not do all that much damage in drama, but consider a judge who holds that view. If there is no such thing as objective truth, how can we do justice? One way in which I think Plato and Aristotle have both contributed a great deal to us. Plato, with his doctrine of the forms, I think gives us a basis for believing in higher law, whereas Aristotle, with his definition of justice as rendering to each person what is due, well, how do you know what's due to each person? or to know what's due to each person, you have to know the truth. Did the person commit the crime or didn't he? And if he did, are there some aggravating or mitigating circumstances we ought to consider in pronouncing sentence? But if there is no such thing as objective truth out there, a judge is perfectly free to give whatever verdict and whatever sentence he thinks advances his own social agenda. There is no objective truth out there that it needs to conform to. Well, anyway, putting those two together, let's look at the living Constitution in theory, starting out with some of the theories of Langdell with Harvard in the 1870s, followed by Roscoe Pound, the dean after him, and then after him, Oliver Wendell Holmes Jr., their prize pupil, who went on to become a Harvard professor and an associate justice of the Supreme Court. But you'd probably describe their philosophy as fivefold. Number one, there is no higher law. There are no laws of nature or nature's God, or if there are, they are irrelevant to our legal system today. Two, law is man-made. Law is law because the highest human authority has pronounced it law. Three, that law evolves, and after all, if man is an evolving creature and there is no higher power to keep law constant, then law is going to evolve as man evolves. Number four, judges guide the evolution of law, and of course do so by writing opinions. And finally, the case law method of legal study. In most law schools today, most of what you will do in law school is read the opinions of judges, because in the modern view, that is the source of law. If the source of law is the mind of a judge, then the most original source that you can get to get a readout of the mind of the judge is a legal opinion that the judge writes. And that's why very often we'll go into court and we'll come out with a case that there's no set precedent directly on point before, and once the ruling is made, we'll say, we just made some law today. That sound you're hearing is Blackstone turning over in his grave. He would emphasize that was not the case. But now let's look at it in practice. A couple cases I'll look at. First of all, Justice Scalia cited this case, Furman versus Georgia, 1972, case involving capital punishment. And the issue here is not whether you or I believe in capital punishment or not. The issue is its constitutionality. And I could say that the court decided 5-4 that in that case, capital punishment as practiced there was not constitutional. That would be an oversimplification because there are 9 separate opinions. That is an oversimplification because each one of the opinions has to identify each point of each other opinion that it agrees or disagrees with. But several different reasons were given for saying capital punishment is unconstitutional. Several said that it violates due process, the way it's done here. A couple said it violates equal protection. But Justice Brennan, joined by Justice Marshall, said that it is unconstitutional under any circumstances today because it violates the 8th Amendment. Well, it is true, the 8th Amendment prohibits cruel and unusual punishment, but it doesn't say capital punishment is cruel and unusual. It seems unlikely that that's what the framers meant by it, because nearly all of them would have accepted capital punishment. Again, the nearly is a legal qualification. I don't know of any exceptions to that. And if you look to the 5th Amendment, adopted at the same time, the 5th Amendment twice sanctions capital punishment. But that doesn't bother Justice Brennan. He says, really, it's true, the framers wouldn't have thought so. But the meaning of the amendment is not fixed and static. Rather, it must draw its meaning from the evolving standard of decency that marks the progress of a maturing society. And that sounds like a nice phrase, a maturing society. But a maturing society could evolve in many, many different directions. And Justice Brennan seems to assume, both there and in his speech at Georgetown University Symposium later, he seems to assume that society is always going to be evolving toward a greater recognition of human dignity and human rights. It could just as easily go the opposite direction and history gives us no assurance that we are inevitably moving in that direction. Another example we could use here is Roe versus Wade of the living Constitution, where in 1973, by a 7-2 margin, the Supreme Court struck down the abortion law of Texas and nearly all other states as well as violating the right to an abortion. Except that you won't find abortion mentioned in the Constitution, as I feel quite certain this audience is well aware. But as to the way Justice Blackmun, quoting from an earlier decision by Justice either Douglas or Brennan, I think Brennan from Griswold, but what Justice Blackmun says is that certain rights in the Bill of Rights have emanations. And these emanations form penumbras. There's a word most people wouldn't bother looking up. It means shadow or aura. And he seems to be saying that as he reads the Bill of Rights, he sees these emanations coming out from it. And these emanations are forming little auras between the paragraphs or in the margins. And there he sees things like abortion for Roe versus Wade, or homosexual rights for Lawrence versus Texas, and so on. Well, I think there are some dangers in this approach to jurisprudence. First of these is that the constraints on federal power are greatly expanded, greatly stretched, if not broken entirely. We could look, for example, at the Commerce Clause power, and as several of you here remember, in teaching con law, I would always talk about the 4 N's of commerce. Congress has the power delegated to it through Article 1, Section 8, to regulate 3 N's: interstate, international, Indian commerce. But one other type of commerce may not be regulated: intrastate. In other words, if you are trucking back and forth between Mobile and New Orleans, Congress can regulate you. That's interstate. But if you're trucking back and forth between Montgomery and Mobile, that's intrastate, and that has been withheld. Now, is that just a technicality? I don't think so. Madison said concerning the Constitution that every word of it decides a question of liberty and power. And that if they had wanted to say that you can regulate all sorts of commerce, they would have just said Congress has authority to regulate commerce. They put in these types with the intention that things outside of that type, like intrastate commerce, be excluded. Well, we get to 1937, actually I think that's 36 if I recall, but right in there anyway, the National Labor Relations Board versus Jones and Laughlin Steel case, where the Supreme Court, by a 5-4 margin, looks at a case concerning a large steel conglomerate. There had been a labor dispute, and the National Labor Relations Board sought to take jurisdiction of that dispute. Jones said, "You can't do that. This is outside of your authority." "Oh yes, we have this authority. Congress gave us this authority under the National Labor Relations Act." And Jones says that's invalid, it's unconstitutional, because Congress only has the authority to regulate interstate commerce, and a local labor dispute is not interstate commerce. By a 5-4 margin, here's what the court said. Justice Hughes, writing the majority opinion, he said if local labor disputes go unresolved, they can lead to strikes. Strikes can lead to a shutdown of steel production. A shutdown of steel production can disrupt the flow of steel in interstate commerce. So if it is necessary to regulate local labor disputes to preserve the flow of steel in interstate commerce, Congress can regulate local labor disputes. And you can see a thread of logic in that. And yet you can see how vastly that expands the power of Congress. Or we can look to the General Welfare Clause, where we're told that Congress has authority to tax and spend, to pay debts, to provide for the common defense, or to promote the general welfare.
Now, I suggest to you that they inserted that word general, not because it just sounded a little more rhythmic or so to be symmetrical with common defense. They inserted the word general as a restriction. They meant that it has to be for the general welfare of the nation as a whole. It can't be just for the specialized welfare of individuals or regions or socioeconomic groups. But in Stuart Machine in 1937, the court looked at the Social Security Act, and they noted that when Social Security recipients receive their checks, they don't just put them in a mattress or hide them in a lockbox. They use them to pay rent or buy gas for their cars or groceries or buy campers so they can drive through national parks at 30 miles an hour and drive me crazy. But anyway, point is they stimulate the economy as a whole. The idea that no man is an island. And so they upheld the act. And since that time, you have seen this idea of the general welfare being applied broader, or more broadly and more broadly, until it's pretty hard to imagine anything that doesn't ultimately promote the general welfare. Now, if you like that interpretation, and I can see the logic behind it, but if you like that, I'm going to ask you to join me in a letter writing campaign. Because I'm trying to get Congress to approve a $10 million appropriation for the John Eidsmoe Benevolent Fund. I think $10 million would be a pretty good start. And I pledge to you, I will use every penny of that to promote the general welfare. Now, I love to ski, and I think $1 million ski condo up at Sun Valley, just think what that would do to promote the timber industry, the lumber and construction industry, the real estate industry, and so on. And I probably ought to have a Learjet so I can go back and forth between Sun Valley and Alabama and promise to make sure that Learjet is manufactured entirely within the USA. All of those things arguably promote the general welfare. But clearly that goes way, way beyond anything the framers intended. So what I'm saying is one danger of this is that the constraints on federal power are greatly stretched and maybe even broken entirely. Second is that constitutional theory then becomes entirely subjective. If we're talking about emanations and penumbras, we're not talking about strict construction or loose construction, either one. We're talking about the Constitution being as Jefferson once said, in the hands of such judges, the Constitution will be a ball of wax. I say we're not talking about a living Constitution. We're talking about a silly, putty Constitution that any judge can take to mold to be anything he wants it to be. And a Constitution like that, as far as I'm concerned, is really no Constitution at all. A third is that other rights that are endangered. Sometimes to expand certain rights, you have to restrict others. For example, if we're going to say that the 5th and 14th Amendment guarantees of liberty include the right to an abortion, then are we thereby restricting the unborn child's right to life, which also is protected in the 5th and 14th Amendments? Well, Justice Blackmun neatly gets around that by saying, with no support whatsoever, that when the framers in the Fourth Amendment spoke about persons, they meant only persons who are already born. But the point of the matter is, we looked at other rights, and as Matt said, the same court that can read into the Constitution rights that are not there can also read out of the Constitution rights that are there. Rights like free exercise of religion, which the court greatly watered down, I think, in the Smith versus Oregon case back in 1990. Rights like the right to make and enforce a contract, which, again, I think the court greatly watered down in the Blaisdell case. The right to own and use property, which I think the court greatly watered down in the Kelo eminent domain case. And finally, the right to keep and bear arms, which the court has upheld in the Hiller and Chicago cases, but only by a 5-4 margin, telling us again just how important the next Supreme Court nominations and confirmations are going to be. And the court's power then becomes virtually unlimited. They're not just exercising judgment then. They are making law in a situation like this. I found this for myself when I served as senior staff attorney for Justice Parker at the Supreme Court, how often I would find it frustrating, and Justice Parker would find it frustrating, that we would have an idea of what was right in a circumstance, but the law didn't authorize us to reach that result. How many of you read Bork's book, The Tempting of America? I recommend you read it. I see you have one of Bork's books in your desk in there. But that was his first book, and I had it for a number of years before I read it, but I always wondered, what does he mean, the tempting of America? And in the introduction, he describes what he means by that. In the judicial sense, the moment of temptation comes when a judge realizes that in the case before him, the law does not allow him to reach the result that he thinks is right. And he says, the judge is faced with a dilemma. He can either enforce the law, or he can bend the law just a little bit to reach the desired result. And he said the former is so arid and unsatisfying, and the latter so satisfying, that he's tempted to do just exactly that, bend the law to reach the result he wants. And a problem is then righted, but a faint crack has begun to appear in the American system of government. A judge has begun to rule where a legislator should. When a judge does that, he is not deciding a case in the sense of adjudging the law, he is changing the law, which means he is making law. I always think back on that example of Lewis Carroll and Through the Looking Glass, where Alice and Humpty Dumpty are having this discussion, and Alice says, well, you use that word, knock down, drag out argument, but how can you use that for what we've just seen here? And Humpty Dumpty answers, when I use a word, it means exactly what I want it to mean, nothing more and nothing less. And Alice asks, the question is, can you make words mean different things? Humpty Dumpty answers, the question is, who is to be master? That is all. And he's right. If judges can make the words of the Constitution mean what they want them to mean, then judges have in effect become masters. And we are in effect, as Professor Grolian at the University of Texas has said, and with only slight exaggeration, we are under a government by the majority rule of a 9-person committee of lawyers who are unelected and who hold office for life. And that is only a slight exaggeration from what we're actually talking about today. I don't think it was ever the framers' intent that judges be given that kind of power. And then what other disadvantage with it? There is no basis for calling a law unjust. Think about the Nuremberg war trials. The Nazi defense was, we were just following orders. We were just following the law of the land. And they were. How can we say they were wrong in doing so? Unless we say there is a higher law, even than the laws of National Socialist Germany or any other country, that trump those laws. In fact, I will make the argument that anybody, any lawyer, who has ever taken a case up to the court of last resort and lost and come out of there saying, we got a raw deal, is in effect saying he believes in a higher law. Because how can it be a raw deal if the highest court in the land pronounced it? Unless there is a higher source of law than that court, and a higher source of law even than the Constitution itself. Well, what's the solution to all of this? Well, now I'm going to go into the main part of the talk here, but we're starting to run out of time, and you're being very patient, so I'm going to try to summarize a little of this. What I'm going to suggest here is rediscovering the enduring Constitution. And let's look first at the biblical framework for that Constitution. And if we look to basic premises of biblical law, and we don't even need to get into the argument here as to what extent that is to apply to our system today, but one basic principle that sets the Hebrew legal system apart from all others is ethical monotheism. Ethical monotheism. Now, what do we mean by that? First of all, monotheism, the idea that there is one God. But what does that have to do with law? What it means is that there is one God, there is one law source. If Marduk of the Babylonians is given one legal code to Hammurabi, and if Ra of the Egyptians is given still another code, and Zeus of the Greeks another, and Baal of the Canaanites another, and Wotan of the Teutonic people a different one, then we have conflicting law codes here. Monotheism means there is one ultimate law code. Ethical monotheism means that for the Jews, law has a distinctively moral dimension to it. If Zeus or the Roman Jupiter has pronounced a law, it's not necessarily right, we better do it because we don't want to get in trouble. But the laws of Jehovah, as we see them in the Bible, are moral laws, and they are right. Now, we could get into an interesting theological discussion whether the laws of God are right because he pronounced them, or whether he pronounced them because they are right. And the answer is yes. The point is, you cannot separate God from his character or his attributes. So, obedience to law, then, in the Jewish system has an ethical dimension to it. And the same with sacrifice. In other societies, sacrifice is common in most societies, but there it's for one or two purposes. To gain the god's favor by, you happen to know that this god happens to like beefsteak, and so we're going to sacrifice a bull on the altar, or maybe we want to avert his wrath, so we show how sorry we are by giving our firstborn son, or whatever it might be. In Judaism and Christianity, sacrifice plays a different purpose. It's not to avert God's wrath or gain his favor. It is to satisfy his justice. Once again, a different dimension. We can go on through some of the rest of the biblical framework, that man is created in God's image, therefore is of infinite value, and there's a certain dignity and certain rights that go with being created in God's image. Nevertheless, that man is sinful, and therefore we need government to restrain sinful nature. And I can go on just a little bit more here. I'm going to skip over a few things, but biblical law contains great protections to ensure that no one is wrongfully convicted. For example, and this goes beyond to the Talmud actually, but in the time of Christ, the law simply was that a person could not be executed for a crime until the Sanhedrin had met a second day to reconsider. And it had to be a unanimous verdict. Between the first day and the second day, criers would go through the streets announcing that so-and-so has been found guilty of murder and sentenced to death. If anyone has any evidence to clear him, let him come forward now. Not a perfect system, but one designed to ensure that nobody is wrongfully convicted. But once somebody is convicted, then punishment was in order. That could be a whole different lecture. But let's look at some other ancient societies. Ancient societies, you might say, still have some echoes of Eden and some remnants of the old law that they had learned in ancient times. I look at Egypt, for example. In Egypt, they had a system of justice that in their view was designed to approximate what they viewed the judgment by 42 gods to be in the afterlife, and they were obsessed with consideration of the afterlife. They had appellate courts and so on. Pleadings had to be in writing. One of the things that I think that we could benefit from the Egyptian system is they had a gatekeeper at the court. And the role of the gatekeeper was to examine every pleading as it was brought. And if the pleading was deficient, he would refuse to file it, he would hand it back, and give him a certain number of days to correct it and then file it. What happens at our Supreme Court, that is the Alabama Supreme Court, as I found it happening so often, and this is frustrating, the people working there were all very, very dedicated, competent, ethical people, but the system itself had some problems. And very often, I'd say close to half the cases that came before the court would be rejected for procedural non-compliance. And then the lawyer is free to refile it, but by that time, the deadline for appeal was probably gone. And I think we can benefit from the Egyptians. Here's something interesting. What would you think if somebody 1,000 years from now were trying to judge the American legal system by reading novels of John Grisham or of Earl Stanley Gardner and so on? That's part of the way we know things about the Egyptian system. A novel that was written about 1500 BC. It's titled The Tale of the Eloquent Peasant. And here is this peasant, uneducated, but a man of great eloquence, who has a grievance against his neighbor. He goes to the courts. The courts keep postponing him, requiring him to come back and re-argue it over and over again on the very flimsiest of grounds. And they're doing it so simply because even though they know he's right, they just love to hear him argue because he's so eloquent. And he finally does win his case. But if I could talk about, as I do in this series, historical and theological foundations of law, I go into the Egyptian, Mesopotamian, Persian, onto the India, to China, the Hawaiians, the Inca, the Maya, the Aztec, onto the Cheyenne and the Iroquois. I find the Iroquois, looking to America, as an absolutely remarkable society in many ways. The Iroquois Confederacy, which had been formed hundreds of years earlier, there are two theories of when, one 1400, the other 1100s, but at any rate, 5 tribes came together, and then a 6th joined them later on, the Tuscaroras. But what I find so interesting about it is the way they balance power. They balance power first between the Confederacy and the individual tribes. They do it using language that was typical of their type of existence, where the council fire for the Confederacy is burning, meaning the courts are open, you're free to come and have your case, but the fires of the local councils are also burning. In other words, their powers are not diminished. They balance power between the large tribes and the small tribes. The 2 largest tribes, the big brothers, propose legislation. The 2 smaller tribes, the little brothers, can veto that legislation, in which case it goes to the middle tribes, and if they can't reach a resolution there, it goes back to the big tribes for reconsideration, and if the little tribes still reject it, then the big tribes and the middle tribes together can override the veto. They have a balance of power between the war chiefs and the peace chiefs. They have peace chiefs or chief lords, peace lords as they call them, the lords of the Confederacy, that govern in peacetime, but they have different lords to govern during wartime. And the war chiefs, who are usually younger, cannot serve as peace chiefs, but they can present grievances on behalf of their tribe before the lords of the Confederacy, which gives them experience. And when they're too old to be war chiefs, they'll probably become peace lords at that time. They even balance power between men and women. Only men can serve as chiefs, but only women can nominate chiefs. They seem to think that maybe women could spot good qualities of leadership in men that men might not recognize. These ancient echoes of Eden. Now, I know I'm running out of time, and I'm going to stop in just a couple minutes here, but we could look at the common law background. I'd love to take a lot of time to talk particularly about the Anglo-Saxon background, going not just to the Anglo-Saxons of England, but back in northern Germany, where because of the Battle of Teutoburg Forest in 9 AD, even though the tribes of southern Germany, with the Visigothic Code and Salic Code and others, pretty much followed Roman law, but north of the Rhine, the tribes of northern Germany were forever free from the influence of Roman law, and Scandinavia as well. And as a result, they had a system of local councils called the Witan, the regional council called the Witangemot, That town council served both as a jury and as a town council to enact legislation. They would elect for each of these councils what was called the law speaker. He would serve a 3-year term. And at each annual council, he was required to recite from memory 1/3 of the law. Over a 3-year term, then he recites the whole thing in front of people who've been hearing this over and over all their lives, and many of whom have been law speakers themselves. In this way, the common law becomes truly the common possession of everybody. Well, there's so much more we can go into here, but I hope you get the idea that when our founding fathers came together, and when they drafted that Constitution, they didn't just come with a blank slate. They had the ideas of thousands of years of wisdom from the scriptures, from the echoes of Eden, from the common law tradition to draw upon. And one principle of common law in particularly this is a characteristic of the German tribes, was their belief that the law never changes, the law is eternal. And that's where Blackstone derives this. Remember the tribes in Germany there, they come across to England around 500 AD and become the Anglo-Saxons there, and the Anglo-Saxon common law they implant there is to a large extent what they had in Germany before. But this is the tradition that we are based upon. And as Washington said as he began that convention, let us raise a standard to which the wise and the honest may repair. The event is in the hand of God. Final thought I'd like to think about here as we look at the meaning of law. And I just think about a sculpture. And you see this rock, and the sculpture might look at that rock and he might think, you know, if I chip it away, I could make that rock into a statue of David, or I could make it into a statue of a man on horseback, or I could make it into a grizzly bear or an eagle, or so many things like that. But Michelangelo didn't think that way. Michelangelo would look at that rock and say, that is David. What I need to do is reveal David by chipping out all the excess rock so that the David that is already in that rock can be revealed. I suggest to you that that is the proper role of a judge, revealing what the law really is, not pronouncing it anew. And with that, I know you've been a very patient audience, and I was going to say I'd take some time for questions, and I've been looking forward to that because I have a lot of questions that I want to ask you. Wait, that's the way we did it in law school, right? Well, let's take a few. How much time do we have now?
We have a few minutes. Clay, I know you had a question you wanted to ask him.
Okay. Let me ask you this, Professor. And the term you've used tonight are echoes of Eden. And the way I'm understanding that, we might say it is a form of natural law. Justice Scalia has been very critical, even though he pays some lip service to natural law, of drawing on sources outside of the American legal system. So I think if you told him about the Iroquois Confederacy or things that were done in ancient Egypt, that would not impress him very much. He would find that to be improper, if not dangerous, I believe is his term. I was just wondering if you could speak to his view and perhaps why he's wrong.
Well, I'm not going to say he's entirely wrong.
Okay.
In fact, I think when you look to original intent, Rehnquist and Scalia represent different traditions in original intent. You look to Rehnquist, you look to a number of his opinions, he'll go into lengthy historical exegesis about how a term has been used at various times, things that were happening at the time that would affect what the framers would have believed and wanted at this time and so on. That's his idea of original intent. Go back to the time and see what was going on. Scalia is more likely to say, don't bother me with all of that. Because anybody can sanitize a legislative record, and whenever you present a legislative record, it's of necessity going to be selective what you state, and we get into what we sometimes call a battle of dueling quotations. And with those who say that this nation did not have scriptural foundations, well, I was accused by somebody of being in a battle of dueling quotations, and I said the problem with that is the other side is out of ammunition. But anyway, Scalia would say, just give me the plain words, and I will determine from the words themselves what they mean. And I think the way I would combine those would be to say that Scalia is right for the first step. If the meaning of the words is clear, we stick with that. There's a principle we use in biblical interpretation that I think carries over. If the plain sense makes common sense, seek no other sense. And I've heard that attributed to at least half a dozen famous Bible scholars. I don't know who said it, but I think it's a good point. But I would say the same with the Constitution. You don't need all that history if the words themselves are clear. If they aren't, then the next step is to go back to the historical context of the time, to see how the terms used, what they were trying to achieve, and so on. That's how I would put them together. Now the question on natural law then, and I am a believer in natural law. I think natural law is going to be most effective when it is informed by a biblical tradition, because otherwise it becomes so subjective. In fact, even Blackstone recognizes that when he talks about the three categories of law. First, revealed law, which he says is found only in the Holy Scriptures. Secondly, the law of nature, which he says is the will of God, dictated by God himself, but we know it through reason and conscience. And he goes on to say that if we could be as sure of the law of nature as we are of the revealed law, they would be on an equal plane. But since the revealed law is written in black and white, and the law of nature is what our reason and our experience tells us to suppose it to be, if there is an apparent conflict between them, we resolve that in favor of the revealed law. And I would agree with him there, but the point I think that he is drawing on is that it is so easy to take whatever our own subjective notions are and call those natural law. I always think about, how many of you remember Aldous Huxley's Brave New World? Some of you have read that, and you recall that when the savage is talking with the comptroller, must have a mom, and they're exploring their philosophies, and I find myself identifying 100% with the savage, but at any rate, when the savage is talking about it being natural to believe in God, and Mustafa Khan says, you might say it's just as natural to do up your trousers with zippers. It's natural because we've been conditioned to do it that way, that's all. There isn't any real nature. Well, the savage is not convinced, and neither am I, but the point of the matter is, natural law is very much subjective, can be very subjective. There should be an objective tradition to draw on, and I hope I've illustrated to you that there is. But if we depart from that, it can be whatever we suppose it to be. One of my seminary professors used to compare your conscience to a compass. And a compass, properly calibrated, is always going to point correctly to magnetic north. Not true north, but magnetic north. But with time, even the best of compasses is going to get off course and won't even be pointing correctly to magnetic north. And so there are machines to take a compass and calibrate it. Well, what he says is the compass is your conscience. The calibrator is the Bible. And conscience needs to be calibrated by the Bible just as a compass needs to be calibrated. That's how I would put them together, and I hope that's somewhat helpful.
Let me ask you this. Where, and I think of maybe the Ninth Amendment, do you think the Ninth Amendment is the area where the living constitutionalists can do most damage?
Well, I'm a little surprised actually that advocates of the living Constitution haven't used the Ninth Amendment more than they have. Now, in regard to I can't remember if this was in Roe versus Wade or if this was in Griswold on birth control, but as I recall, while most of them wanted to rely upon the life, liberty, and property without due process concept of the 5th and 14th Amendment as the basis for the right to privacy, Justice Goldberg, in a concurring opinion, said that it makes more sense to base that on the Ninth Amendment. Here's the problem, and the idea is that the Ninth Amendment then is some sort of catch-all for rights that are not mentioned in the Constitution. The problem with that is the word retained. The enumeration of this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, the Ninth Amendment does not create any new rights. It doesn't authorize the creation of new rights. It only is there to protect rights that are already recognized and recognize these rights as being retained. The concern that, in fact, Madison, when on the floor, when he was asked about the purpose of that amendment, noted that some, and particularly Hamilton, had said that the danger of the Bill of Rights is that if you start naming certain rights, what happens to the ones that you forget to name, like the right to breathe oxygen, for example? Are we going to say that those rights are forfeited because we didn't name them? And Madison said that's the reason for the Ninth Amendment. We're simply saying the mere fact that we've named some rights here does not mean we're forfeiting any others that we haven't named. But again, the word retained, I think, is the operative word there, and that, I think, militates against giving that any living Constitution interpretation. Others? Well, I appreciate the chance to be with you. Like the
For those of who want CLE credit, please make sure you fill out the speaker evaluation form. And also, when you sign in, leave your ASB number as well. I do want to announce that we have confirmed our speaker for our next event, Tuesday, September 17th. Will be retired. Well, no, he's not retired, but he's no longer. He's going to private practice now. But Judge John V. Denson of Lee County, he's going to speak to us on free speech in wartime, and the Espionage Act, particularly a case where his cousin was prosecuted by the United States government, United States versus William A. Wild Bill Denson. Wild Bill Denson was charged with violation of the Espionage Act for saying Wilson is the cause and the whole cause of the United States being mixed up in the European War. Wilson should be hung, and I would like to see him hanged. So Judge Denson's got some really, I've seen this presentation, it's really good, and I thought now with the Espionage Act becoming in vogue among the federal authorities, it would be a good time to renew our review of that act. So that'll be September 17th. I will get an email out to all our members as well. As always, thank y'all everyone for coming. I know Colonel Eldsmoe drove down from Pike Road tonight, and I think he's going to go back tonight. He's going to be speaking to the Montgomery chapter, I think, this week as well. So you understand why, as a student of his, I was really excited that he accepted our invitation. And we thank you very much for renewing our interest in the Constitution. Thank y'all. Oh, one more thing. His books and his CDs and DVDs are